Hi, everyone. Welcome back. It's Frank Ravitch and Larry Backer. We are looking at the Supreme Court's very, very important and to at least some of our minds, somewhat problematic transformational jurisprudence in the religion clause cases in the 2021-2022 term. For those of you who've already seen it, we spoke earlier about the Carson case. This is school funding and vouchers. Today, we're going to talk about what I view, and sorry, I have to do this, and this is a religion clause thing, so God or some reasonable facsimile thereof, or some divinity or some secular version of this, either in man or nature, forgive me, but this, for me, was one of the best examples of jurisprudential gaslighting I have seen this century. I really had to stop reading the case. This is a Kennedy case we're going to be talking about, prayer in the middle of a field. I had to stop it and actually go to Netflix and put the movie on, the gaslighting movie, just to remind myself that there may be a difference. So anyway, today we're going to talk about the if we were looking at this in mythological terms, the utter triumph of free exercise over and through the Establishment Clause in its heartland. And the case is just incredibly rich, but I'm done being emotional for a moment, and we will be much more analytical. The case is very problematic, not necessarily for its holding, which is plausible, but for the route, at least for me, the route that they got, they go there. But let's start with Frank. Frank, what do you think of the case?
I try not to. Gaslighting. It is gaslighting. It's gaslighting on the facts, and it's gaslighting on the law. As you said, the result is certainly feasible if the facts were even remotely close to what the majority suggests they are. The facts, I encourage anyone who has any question about what the facts really were, obviously read the dissent, which is the first time you actually see the real facts, but go read the record. The dissent actually went easy on the majority in terms of its factual gaslighting. Go read the record in this case. This is a case where reading the record, it demonstrates this is not normal factual factual puffery. Courts do that a lot. They spin the facts in a way that and SCOTUS does it as well. That tends to support the ultimate way they analyze the case. This goes way beyond that. This is true gaslighting, if not almost making up a narrative or just taking it directly from certain briefs and ignoring things that are in the record, photographic evidence, all kinds of other evidence that suggest that the facts are completely different. So I agree with you, Larry, that there is a way this result could be okay, but it assumes a parallel universe in which the facts are what the majority said they are. And then the majority also, as we're going to spend a good amount of time on, gaslights us on the law, including not citing the most relevant precedent that talks about the endorsement approach, why we have the endorsement approach, why it is not what the majority says it is, and why it's relevant to a situation like this where there's a history of behavior by this coach. And that's the McCreary County case. And what would happen, Larry, if a lawyer did not cite a directly relevant precedent and cited all the precedent that goes in the lawyer's favor? What would happen to that lawyer?
Right. No, we all know this is an ethical dilemma. And again, this is something that we already saw in Carson. It reminds me of very, very smart toddlers who are trying to hide something from mom. If this is what you want to do, and I have no problem with this, because there would have been a way to reach this result. We may not have agreed with it, but there would have been a plausible way.
Just be honest.
But they were not honest, right? And that if you were a lawyer, your reputation would be shot. And certainly we would have a discussion about how we could, whether to what extent we could actually trust you as a lawyer in a case like this. You own up to it. And you can say, look, I thought this case was dumb. I don't like it. I'm going to treat it as if it is limited to its facts. There it is, boom. And if it comes up again, you'll know how I feel. And then, blah, blah, blah. But this kind of, and, the courts have done this occasionally. We saw this in Carson, ignoring the Smith case, but it's the rate at which they're doing it and the strategic ghosting of cases, and the strategic ghosting of jurisprudence has gotten really bad. And one last point,
it's combined with the mischaracterization of other precedents. So right.
But there again, I just want to underscore your point, which is absolutely right. This isn't Good News Club, right? Where you could interpret what was going on in vastly different ways. And you recall it was two different worlds. But there was no question that they agreed that they were looking at the same thing. They just saw two very different things. Here, you're not even seeing the same thing. It's like, I don't know what field what football field you were looking at, but the majority's 50-yard line seats are very different in probably some other part than the dissent and the picture.
I would say the majority's 50-yard line seats are either pure fiction or are existing in a parallel universe, whereas the dissent seats are firmly based on the record.
Well, they were very careful. There's two sentences roughly that says, this is all me. This is all me. I am a holy person in the wilderness. And oh my goodness, I turned around and look, I've got disciples. In fact, the entire football team, and in fact, other people. And then I found, I'm a holy person. I find a hill of some kind where I can also turn around and preach. Right. The illusions are clear, but I'm not going to, if you know it, great. If you don't, that's okay too. But that's what they did in two sentences, saying, oh, look, this is all completely personal. I'm oblivious to everything. And wow, these people show up and there it is.
I never mind the fact that the coach called the media's attention to it, that the court ignores all the prayer that there's stuff you don't even find out about until the dissenting opinion, right, which is directly relevant also to the history and tradition test that the majority essentially moves into being the main test, as though that was always the case, and of course it wasn't. The reality is, if you look at the record the way it actually is, he loses under the test the majority claims to apply. Of course, they spin the free exercise and free speech analysis, particularly the Garcetti analysis, under the free speech clause in a way that that is itself problematic. But if you look at what this coach actually did, the framers would have had problems with that because of the fact that it was extremely sectarian.
Right, but before we get to the jurisprudence, and I know you're dying to get there, and I am too, but I wanted the facts. There's one last fact, and this is an opportunity for you to talk about the effects of this case on religious minorities, right? The crux of the description, right? Because we're looking at two different things. The crux of the description for the majority was engaging in quiet personal prayer. Mm-hmm. And on that basis, they do the balancing and the like. If you look at it from the perspective of the idealized, which had nothing to do with what was going on in the field, the ideal that they were jurispruding about, you also worry because what it suggests is, as long as you're engaged in Judeo-Christian style prayer, quiet, personal, it's all cool. and we'll apply the religion clause this way. But we move beyond that religious tradition for communing with the divinity, and all bets are off. And at this point, you have to ask, oh, I see. So we have the neutrality of Carson, but apparently the neutrality, because we're now adding a balancing test, the neutrality only applies to this ideal, and the ideal is an Abrahamic one.
Yeah, I'm not even sure it's completely Abrahamic. I'm not sure how inclusive it is of Jewish prayer, but if you look at this, okay, if this guy just quietly was going to the 50-yard line to pray after everybody was in the locker room, as the majority suggests, or on their way there or doing other things and not calling any, okay, maybe there we've got, that's more good news clubby. It's more truly private speech. It's more likely to happen. It's more likely that certain groups within Christianity are the ones that are likely to do that. And there's nothing wrong with that. That would be protected, and there really wouldn't be much of an establishment clause issue, right? But that's not what happened, right? And so the problem is that applying the approach that the majority applies to what actually happened here does exactly what you're saying. It interprets the free exercise clause and the free speech clause in a way that are very likely to favor religious speech of a certain subset of Christians. And in all likelihood might view, for example, somebody who has, who uses drums in their prayers, or, who uses verbal out loud chants in their prayers, or who needs a certain number of people to pray, even if they're all private citizens. These are going to be viewed at the very least as disruptive, potentially. And they certainly might be viewed as, not this quiet sort of, certain forms of Christianity, certainly not all forms of Christianity.
Right. Individual private prayer is the only thing that seems to be here. All right.
Yeah. It misportrays the facts to suggest that this was actually individual private prayer. Again, if it is, like you said, I don't think anybody would have much of a problem with a coach going and privately praying, even at the 50-yard line, if the students aren't focused on it, if he, but again, anybody reading this case, look at the dissenting opinion and then look at the record, and you will see that isn't what happened here.
Right. And
this guy was not quiet. He was not. Yeah.
Right.
This was like a what's it called? This was like a like a tent meeting.
Right. Yeah. And well beyond formalism, and that's weird. So let me ask you something. So is the Establishment Clause now the only test that we use in the Establishment Clause, the test that is set out in Galloway, and that all other tests, the endorsement test, the Lemon test, and all distinctions between situs, that is, whether it's in a pre-university, pre-secondary or post-secondary education, all of that gets swept away, so that when we look at the Establishment Clause now, the only test that is now recognized that has not been swept away is Galloway and the historical test.
Yes and no. I mean, this is sort of part of the legal gaslighting, right? The court clearly says that Lemon and endorsement are not really followed anymore, although it doesn't really say anything about, well, what about in the context of, like, school prayer, or organized, school prayer. In that context, it does cite Santa Fe v. Doe and Levy-Weissman, and it suggests that the coercion or indirect coercion test may still exist, but it seems to water that down a bit to almost more direct coercion. And it completely ignores the fact that Santa Fe v. Doe was also very heavily based on the endorsement test, that both Lee and Santa Fe relied on Ingle v. Vitale and Abington Township v. Shemp, which looked at purpose and effects, pre-Lemon. And so what we're left with is this idea of, well, maybe it's different when the government is doing the prayer, at least in a context which might be coercive. My take on that is, given the Trinity Lutheran Espinoza Carson v. Macon, where it was all sleight of hand, and then suddenly everything's gone, right? And in Carson, really Espinoza, but certainly Carson, I think it's very hard to trust the current court that it's not going to do something similar, given its new balance between establishment and free exercise. It's not going to do something similar to what Justice Stewart suggested in his dissents in Abington and Ingle, and end up with public school prayers. Okay, it's not really coercive as long as there's an excuse. I'm not saying it will go there, because the court does cite Levy-Weissman, it does cite Santa Fe. But one important thing to remember is Justice Stewart was genuinely concerned about religious minorities. He would have overturned, the Braunfeld v. Brown. He would have maybe found an Establishment Clause violation in the Sunday closing laws, which this court clearly wouldn't, because it cites McGowan.
Which was, exactly.
So Stewart, this court is not Justice Stewart. Let's put it that way. This court, right, I don't think can even conceive of what it feels like to be a religious minority,
or to be upfront about the real concerns. There's no courage here. They're hiding behind a slippery jurisprudence that begins to sound like magical incantations that will make people dizzy, because you're going to have to know them inside and out. And at this point, the court becomes remote. And again, we're back to gaslighting.
And I think if anybody, it is. I mean, you're exactly. It's this is not a term that I would ever throw around lightly, because it's a very powerful, it's a very strong term, and I without the failure to cite McCreary County, without the incredible, beyond normal twisting of the facts, even the gaslighting under the law, I would not use this term. But there is almost an element of intellectual dishonesty throughout this opinion. And I hesitate to use the term only because I believe that these justices in the majority are completely incapable of seeing other perspectives.
Oh, no, they embrace the idea and the great.
And because of that, I think that maybe it's less intellectual, just like an intentional thing, and more of a gaslighting without even realizing they're gaslighting.
It's intentional. It's intentional. These are the same people who brought you that humongously interesting and important discussion about precedent and its overturning in Dobbs, none of which appears in a case in which you are taking 50 years of jurisprudence and chucking it out the door. Actually,
well, particularly because they ignore the most important, reliance in Dobbs. They ignore reliance.
Right. This jurisprudence goes all the way back to Everson, right? They are chucking it. We have the benefit of the standard for chucking this mountain of precedent in Dobbs, and yet none of that makes its way here, other than, oh yeah, a lot of people we don't like this case. Here are a number of opinions about it. And that's enough.
And the irony is they never literally say in the opinion that they're overturning Lemon and that they're overturning endorsement. The dissent says that when you read the majority opinion, it is clear they are overturning Lemon. And the only reason I say apparent that they're overturning endorsement is because they practically say it, but then they do cite Santa Fe v. Doe along with Levy-Weissman when they talk about more organized, more like football game prayer in Santa Fe or graduation prayer in Lee. And Santa Fe, yes, it did rely on indirect coercion, but it also relied on endorsement. and particularly in a context where the school claimed free speech. So, it's really slippery, right? But you're right, they do. I mean, whether they say they're overturning Lemon, literally, like in Dobbs, they say we're overturning Roe. And of course, they ignore the most important stare decisis factor in a case like that, which is reliance. And while they might be able to argue in Kennedy, the reliance on Lemon has lessened over the years. Reliance on endorsement, until really very recent cases, right? Really until sorry, I'm having a brain. The cross in the middle of the square in Maryland.
Oh, right.
American Humanist Association. Until that case, and in that case, it was understood it was limited to that case in World War I memorials. Endorsement was still alive and well. The day Van Orden was decided, McCreary County was decided. Yep. Right. And so, the endorsement test has been relied on. It was relied on by the school district, right? And for good reason.
Right. Now, here's an idea. What they may be doing, and this is why they were able to cite Lee and were able to cite Santa Fe, they're going to transform endorsement from attached to or derived from Lemon to endorsement as an important element of the historical test. So that if in fact you have a historical endorsement, then endorsement remains, but it is now a vat of evidence, but now subsumed not within the Lemon test and its rich history, but now within this newly reinvigorated Galloway test, which was this little itty bitty thing that's now eaten the whole thing.
Well, and the problem with that, first of all, I mean, that would be better than nothing, I guess, right? I mean, all the tests under the Establishment Clause, I mean, there's this tendency for scholars, we're as guilty of it, but also for students, for everybody to think, well, this is a great test and this is not as good a test. I mean, I think sometimes we're really talking about the least shitty test, right? And in the Establishment Clause area, same thing with free exercise. No test is really great. What we're looking for is one that actually works and manages the situation reasonably well and has some legal and historical basis. Right. And endorsement was the best of those, because it balanced, at least in some ways, religious outsiders and insiders.
Right. For all of its craziness at the margins. And I have never not been a fan of endorsement, although I really like the pre-Lemon test as well. But and I am sympathetic to the historical test. All of them, arrows in the what do you call the
quiver?
Yeah, arrows in the quiver.
But who's wielding the quiver is the question under this new historical, because what amazes me about this is that both sides accuse the other of cherry picking history, right? And both sides are right. There's history and tradition that supports almost anything, right? So you cherry pick, but the sad thing is if we look at what is truly long-standing history and tradition on religion from the time of the framers forward, there's only a few, and they're pretty disgusting. Mostly anti-Catholicism. That's the one thing that went from the time of the framers all the way through the 1960s.
Oh, don't forget the Anabaptists and the Mormons.
And and then I was going to say the next thing is the persecution of the Anabaptists. Right. And then the persecution of the LDS Church. Right. And so, and there was persecution of Jews and then atheists. And so if we want to go back to the time of the framers or the time of the framers of the 14th Amendment, the only traditions that are sadly and horrifically consistent are anti-Catholicism, anti-Anabaptist sentiments and anti-LDS sentiments. These are documented. They are sadly and horrifically consistent.
Yep.
And there's very little question that those were traditions. I would never support them. I would never uphold them. But then again, I would never rely on a fakakta, tradition test where you just cherry pick the, when the next court comes in with different traditions, and suddenly the traditions are, we've been an atheist country since the start because Tom Paine was atheist. That's fine. That's just as good as what this majority does.
Now I have to do this. It's killing me, but I have
Sorry,
to
I'm going over the edge
I have
here.
to do this. In their defense, I
did use the word
what they're trying to. So I'm going to try to pull something defensive here. In their defense, I think when they speak to history, they acknowledge these things that now fall within the area of taboo. And what they may be trying to do is use the history test to generalize the discussion about neutrality that was once limited to fights between the Baptists and the Methodists, or between the Episcopalians and the Congregationalists, using that as the baseline, the inter-Protestant discussions and the inter-Protestant notions of toleration and equality and all of that, and then generalize it to everyone else. If in fact that's what they mean to do, that's a nice solid basis for taking the historical approach, like we've taken every other approach, and to mold it into something that, again, can be predictable, fair, protective of minorities, understood that we're now generalizing, and it's not just limited to fights between the Baptists and the Lutherans, but now it includes everyone else. The problem is, of course, you and I have to speculate that that is in fact what they mean to do, that is in fact what they have done, and that is in fact what the future jurisprudence is going to look like. And right now, all bets are off.
Well, and that's the thing. I mean, if they do that, it's sort of a form of maybe Cass Sunstein's broad originalism, right? And if you're going to base it like that, there is a way to do that, right? But I don't see indications from this court that that's what they're going to do.
Right.
And for those not from the East Coast, I should apologize. If you don't know what fakakta means, it's not a curse word. It is not a curse word. It means it's like bullpucky, or
messed
like
up. It's
like messed up,
right.
basically. And so at any rate,
wait.
Yeah, I do think.
Wait. That's a great entree for messed up. We have to do this because I know our time is sort of limited, and we have to get to two other things. And I
just want to make one more point about your broad point about the extrapolating from the inter-Protestant disputes, is that that you're right, that could lead to a very tolerant approach. But the problem is that you know as well as I do that there were periods within those differences where Congregationalists were at the throats of Anglicans, Anglicans were at the throat of Congregationalists, Congregationalists and Seekers. That's why Roger Williams went and founded his own colony, right? Now that was before the framing, right. But we know that was going on even in the 19th century. So there is some concern even going that route.
Oh, sure. And and part of the jurisprudence would be to fix it. But again, we're speculating. And we can only hope. But I want to go back to messed up. All right, so here's the messed up part. I want to hear your views. The First Amendment's free speech worm in this free exercise establishment apple. What's your view of Gorsuch's use of the free exercise element in the case?
Free exercise or free speech?
Sorry, free speech. Sorry.
Let me take a deep breath.
Yeah, I knew you were going to have to.
Meditate a little bit. Pickering Garcetti, have to do with Chan or something, of course, Garcetti itself was somewhat a controversial opinion. Look, I have generally, and I know we disagree on this a bit, I have generally been a fan of very strong support for truly private religious speech. I even reluctantly agree with the Good News Club majority, albeit very concerned because we're dealing with elementary school kids and the nature of that club. But if it had been middle school or high school under similar circumstances, it would have been pretty easy for me to. I'm a big fan of the equal access principle. I'm a big fan of truly private speech being, truly private religious speech being protected as religious speech. But we see many cases where there's an attempt to misuse that, right? The school district in Santa Fe tried to argue that it was quote unquote voluntary student initiated prayer. But if that's the case, it was a free speech violation because the school district was siding with the majority speech and not providing alternative speech operations, right? So the problem with the majority's use of free speech in Kennedy is the same thing, right? It is suggesting that Kennedy is somehow existing in this private speech, maybe public forum. It is on government property. He's on his own time, and
well, there's a question about that, but let's
yeah, there is a question about that. I mean, but this is the majority statement.
Yeah. Let's
right?
Okay.
So if this is the problem, if we look at that approach, the equal access approach to free speech, which I generally do support. Again, Good News Club is this where I'm a little torn on it, but in the other cases, Widmar and Lamb's Chapel, all those, no problem. The problem here is that, if this guy was just quietly, like the majority says, going to the 50-yard line and bowing, then yeah, I think the majority's analysis is correct. Whether I don't even know that you need Pickering and Garcetti there, but because there would be a question about whether he's acting as an employee. So I guess you do need to talk about those cases, but he'd probably win even under those cases. The problem is, again, that's just not what happened. And the end, when you are a school employee and particularly a role model and students can see you, and this is why I don't think they took Levy-Weissman that seriously.
Right.
There is coercive pressure. I played sports, right? And I ended up transferring to a private school in 9th grade because I got into a lot of fights. There happened to be some anti-Semitism around, but at any rate, and I didn't start anything, but I didn't,
Right. Yeah. No,
so basically, but all joking aside on that, I did have a middle school coach that did sectarian prayer. Perfectly nice guy. I don't think he probably would have discriminated against me. But I will admit to feeling torn. Like, should I go over there? Because players were like, should I go over there? Like, what should I do? And I decided not to. But I worried, and if I had been, maybe if it had been high school and my college scholarship would have depended on it, maybe I would have gone over there because I'm worried. You've heard of players losing their starting positions because of that kind of thing.
Right.
So that's no longer Good News Club. That's no longer, and that's the court misanalyzed Garcetti.
Well, you're being nice. You're being nice. I was going to be less nice here.
Well, that's only because that's like all the gaslighting in the case. That's the one where there's like a kernel of something.
Right. You're much nicer about this than I am, because I viewed that whole discussion not just as a red herring, but as a very deliberate effort to use the so-called free speech element as a backhanded way of trying to move that neutrality argument by suggesting effectively that there is a lack of neutrality here because secular speech would be protected in a way that religious, quote unquote, religious speech would not, assuming that an equivalent form of quote unquote secular speech would have been tolerated no problem, as opposed to his. It's not clear that that would be the case. It's not clear how Garcetti would come out. It was not part of the case, but it was a great, this is their agitprop moment. So they raise this thing up, and then they use this to kind of just slap on the side. It's a flank attack. And then they say, oh yeah, but don't worry about it. It's, we think it's okay. But we wanted to bring the speech thing up. And in fact, when in all of these cases, I read this and all I kept thinking of was that horrible opinion in the Summum case.
Oh yeah.
The horrible opinion, because it's the same thing. Now all of a sudden you're going to get all self-righteous, and then you're going to start talking about speech when we know that, okay, I'm going to take you at your worst, and now I understand what you're doing, so that when you don't like a minority religion, like the Summum case, and that was completely, from the American tradition, completely at the margin. When you don't like it, okay, then we have another arrow we can use. We'll just go off on the speech thing, or we'll go somewhere else. And all of a sudden, in the most cynical reading of the case, we are able to sort of adjust how much privileging which sorts of religion will get and how much privileging they won't. But we don't appear to be doing that because now we have all of these other levers that we can use.
That's a good point. And in fact, to even add to that, the Summum case left open the Establishment Clause. Pretty clear they were violating the Establishment Clause under the tests at that time, right? If there had been an Establishment Clause claim. In fact, even the 10th Circuit in its original opinion suggested you shouldn't have dropped the Establishment Clause claim. But now, I mean, would there be a valid Establishment Clause claim there? Certainly we would think McCreary County would apply there because they were favoring the Ten Commandments monument over other monuments. But after Kennedy, we don't really know if that would apply. And then, as you point out, it's interesting what you're suggesting. And actually, I think you're exactly right. Now that you've put it that way, what they're doing is they're free speeching Carson v. Macon and Espinoza. And what they're saying is, if you, or maybe even Fulton v. City of Philadelphia, if you include secular speech of any kind, then you can't exclude religious speech without a free speech violation, which was already the law. But now your Establishment Clause interests are no longer particularly powerful as a rebuttal to this, right? Before in Good News Club and all those cases, there, again, you can read Souter and Stevens' dissents in Good News Club, and you get an idea. There really could be some debate about whether there was a valid Establishment Clause concern, but there the school was going against religion, not in favor. So, whatever. Right. But the reality is that what they did in Espinoza and Carson is lower the power of establishment rebuttals to free exercise. Those were state rebuttals. Now they're lowering the federal Establishment Clause rebuttal power, compelling interest, narrow tailoring. And so they're re-upping. So you've got a double-sided club to beat establishment with free speech and free exercise.
Right. And what you've made the excellent and basic point here, and the one that everyone ought to be thinking about. What is left of establishment after Kennedy?
Yeah. And maybe the coercion test, and then handpicked traditions. One of the problems, and I've written about this a lot, in religious symbolism context, in the school prayer context, in the funding context. I mean, the reality is that when you go to a tradition test, it become or an originalism test, or in this case, I think they don't rely strictly on originalism and strictly on tradition, so that if they can't get what they want out of tradition, they can use originalism and vice versa, because all the traditions are not consistent with the understandings of the framers. And so, you know, what we end up with is this ability to cherry pick traditions that sit comfortably with the majority of the court, and the intent. So it becomes a battle of the framers. It becomes a battle. Whose history are we looking at? Whose traditions are we looking at? And it's an area that historians don't agree on. So, you know, it just becomes an excuse for an activist court. That's the problem with originalism in an area where we don't know original intent. Look, if we know original intent or original understanding, okay, maybe there's something there. But if we don't know, or it's indeterminate, then originalism or tradition just becomes a facade to hide behind for an activist court. Right. It becomes a way to do what you want without acknowledging that you're changing anything.
Now I got a question for you before we get to the free exercise part. I'm trying to save the best for last. Right. So you and I are members of a, let's say, a traditionalist law firm. After reading Kennedy, I come into your office, knock, 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 and I say, well, you know, we've been working for 20 years on we're instrumentalizing the Constitution, blah, 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 for this. Is it now, here would be my question to you. After Kennedy, is it now time? Are we ready to go after Engel and Abington?
You know, I think the court opens the door potentially to that, right? If Lemon is no longer good law, and Abington's relied on what essentially became the first two prongs of Lemon, I think that there is, I certainly think that the culture warriors, or if I was in that traditionalist firm, I would already be thinking of ways to use that. Now, the one thing that we would then have to discuss when you came into the office is, okay, but Engel did rely on history and tradition, right? And so now, of course, we have to come up with a counter history and tradition, which these justices already have in American Humanist, in Town of Greece. And so it should be easy enough to do and just say that Engel's interpretation of tradition was wrong, right? But I think that we would have to, so that would be like a three-step process. One is, yes, Larry, we can go there. We can try to get rid of Abington. You could say that. And then, but Engel does rely on history and tradition. Yeah. So we just need to cherry pick our alternative history and tradition. I mean, in some ways, Engel did the same thing, right? I mean, Engel, Justice Stewart points this out in dissent, right? In Engel. Right. So, you know, in some ways, Engel did the same thing. So now we'll just do that, right? So, and then the third thing is, but we still need to consider the coercion, indirect coercion.
Right. But like Kennedy, all we need to do is find the right set of facts.
Well, we don't even need to find them if we're going to be like Kennedy. We'll just make them up.
No.
we just need a record from which we can make something up. Right. I mean, I mean, if we don't rely on the actual record and what actually happened in the case, then what you know, yeah, we just need to find a case that we can you know, be advocates in, that we can get cert granted. And as long as they're facts that the court can spin well enough, we can maybe get rid of indirect coercion too.
That's right.
Although I don't know that Kavanaugh would, of the justices in the majority in Kennedy, I don't know that Kavanaugh would be willing to get rid of indirect coercion or coercion. And I'm not sure that Roberts would either. So I think that if we were in that traditionalist firm, we would need to figure out how to deal with coercion, or maybe just live with it and it's good enough to get rid of the others.
All right, so I have the action plan. 3 cases. You know, there'll be dozens of cases, but 3 spheres. First, you get them to get rid of this no coercion in high school. Then you find facts, you build on the high school case to go to middle school. And then you'll have enough knowledge so that you can actually develop a kind of approach in elementary school that will ultimately knock the whole thing down. So if you're looking at this from the long term, that would be the way I would go about it.
Wait, that would be like Trinity Lutheran, Espinoza, Carson v. Macon.
There you go.
But I, you know, and I do think that the first of those is very possible, right? To say that high school students are old enough. You know, if I was going to do a 3-step, if I was in a traditionalist firm trying to get rid of the indirect coercion test, I would do it in a slightly different way. What I would do is try to get them, because there's hints of this in Kennedy, try to get them to redefine coercion away from the truly indirect sort of peer pressure first. So make it closer to real legal coercion, which I don't think any justice has a problem with, right?
Right.
You know, that I think would clearly be unconstitutional. You know, if you don't pray, you're suspended. I mean, that would clearly be unconstitutional.
Right, and it'd be
So try to
great in the
move
high
it
school
there.
context. Right.
Right, and then move to your first step, which would be, and in the high school context, really, it is this. It isn't more direct coercion because these kids are old enough to understand. And then maybe go for middle school on that. I don't know then that you could go to elementary school, but since coercion will now have been redefined, you get almost everything that you want if you want to go that route. And the problem is, as someone who would likely be on amicus briefs or whatever on the other side,
Right.
you know, the real me, you know, I have to think to myself, how do I fight this? I'm boxing with shadows. I mean, I don't know if they're going to look at the facts and the record seriously. I don't know if, you know, I'm going to argue for traditions and I'm going to argue for history, right? I'm going to, you know, poor Steve Green, I'll be calling him every day to check in and see what he thinks, you know, about the history and tradition, because he's written a lot on these histories and traditions. And anybody, you know, anybody that I can think of to try to figure out, how do I frame this? Because I know it's going to be framed the other way on the other side. And I don't really have a coherent legal test to lay my hat on. So I'm going to really argue hard on indirect coercion, as though Kennedy didn't move us away from the Lee interpretation of that.
Right.
And really stress how much Kennedy cited Lee.
And then what I do is I Carson you from the
Yeah. Oh yeah, of course.
firm.
Yeah.
And what I would do is, in the elementary school, I would create a program that I could then sell as a program of parental choice.
Yeah, and you know, that's the sad thing about this is, if I wanted to come up with a way to use these opinions to promote religion to the greatest extent possible in public schools, and my teleology, my goal was to use the public schools as a way to promote a particular brand of religion, I think it would be really not that hard to do after these cases.
Okay.
If your goal is
If you're
clever, but you know they're clever.
Yeah.
The people that are going to make those arguments, well, sometimes they're too clever for their own good, but they're clever, you know. But the people on the other side, the problem is that now you're boxing with shadows. You know, you don't know what will happen when you get up to SCOTUS. You know, the likelihood that your position is going to be, so you're going to have to figure out. It's going to all be in the framing for the people trying to promote protection for religious minorities, like myself, who are trying to protect religious minorities, people who are trying to promote, you know, an anti-establishment approach. And you really can't say separation anymore after Kennedy, but
that's gone.
But you know, I mean, you could say it, but the problem is there's not much left of it. After Carson and Kennedy, you know, it just gets much harder, right? Because you're not fighting reality. You're boxing with shadows.
Right, but you've also got the Ginsburg problem. And,
right.
And if you're in, now we're going to switch from the traditionalist firm to the progressive firm. or even the protecting minority religions firm.
Yeah, like
say.
people like me who support
Right.
religious free speech, but
Right.
also support the protection of non-believers and religious
Right.
minorities.
And the problem is that that may well contain a contradiction
Well,
that then
now it does. It
weakens,
didn't
right,
before.
now it does, that then weakens your ability, because in order, and this is your boxing with shadows, in order to move forward in one, you may necessarily have to sacrifice the other. And if you don't want to sacrifice either, it becomes very difficult.
I think you're exactly right.
No, and that becomes hard. But we've got just a little bit of time, and we've got to save it for the most fun part of Kennedy, although we've been having a lot of fun.
Yeah,
Free
we've been
exercise.
yeah, that's we should do the progressive firm, but with the time, I think you said it. You were exactly right. Unfortunately, there's not much left other than just working with what you've got, and I don't know how people like me, what we're going to do, right? I supporting religious free speech, except for say we support it the way we thought it was understood, the way the school district understood it. If you read the school district's policies, they were completely consistent with the law as it stood in 2021.
Right.
Right.
Which is what made the case perfect and perfectly timed now. I mean, this confluence of facts just made it perfect.
Yeah.
Just perfect. But yeah, no, and actually one of the more interesting things will be to see, once the progressive side gets done whining, to see what it is that they think they are going to be able to do in the face of a very strong and a very coherent project on the other side.
That's absolutely true. Yeah.
And that's a problem.
I wouldn't say that the progressive side is whining. I'm a moderate, but I
they're going to have to. There's this period of mourning, right? And so
I would say
the first flush of law review articles are what I call the whining articles. Woe is me. This is terrible. What are we going to do? Blah blah. Before they get to where they eventually have to go to is, well, what do we do now?
That's kind of what I'm working on now as an article. So, which is the what do we do now part. And by we, I don't mean progressive. I mean anybody who has any care at all about the last 60 years of jurisprudence having any sort of coherence going forward.
Right. But also for traditionalists, right? So if I were to look at this through my traditionalist lens, there's a lot to be done here. There's a lot of sloppiness. There's a lot, you can be unhappy about both Kennedy and Carson from a traditionalist perspective, as much as you are from the opposite side. There's, in their eagerness to tear down their grandparents' jurisprudence, they've made a mess. And it's a mess that dirties both people who feel very strongly about a more traditionalist view, right? Going back to some of the larger principles in Smith, as well as people who really want to preserve that house that was starting to be built in the late 1940s. So both sides are going to have things to do to clean up this jurisprudence that they've the toddlers have come in and they've knocked this thing down, and now the grown-ups are going to have to come in on both sides and try to figure out how to make this work plausibly, whether you're Justice Stewart or whether you're Justice Brennan.
Both of which are turning over in their graves right now.
Yeah,
Brennan for what's happened to all three clauses, Stewart for the way the free exercise and free speech clauses have been misused for majoritarian purposes.
That's right. So let's talk about free exercise.
Okay.
All right. So what do you think about their approach to now the dominant analytical form for the religion? I was going to say clauses, but now we probably ought to just use the singular, the religion clause, which is free exercise with a subordinate establishment clause proviso.
Yeah, if we're going to call it the sort of the religion clause, I I think, Stephen Carter's approach to that was much more thoughtful, or is much more thoughtful than what this court's doing, right? I mean, you can agree with what Stephen Carter said, or not agree with what Stephen Carter said about it being a religion clause, but it's deep, it's coherent, it makes a lot of sense. Whereas this majority's approach to the quote unquote religion clause is kind of patched together through this sort of network of cases. And you see it, the way the court uses Espinoza, the way the court uses Carson, the way the court uses Masterpiece Cake Shop, Fulton v. City of Philadelphia. And you read through it, and what you get is this sort of sense that anytime you distinguish or single out religion, obviously that would be a Smith violation, but anytime you single out religion, that's a free exercise clause violation. So technically, any of the past Establishment Clause cases would have led to, well, no, that's disfavoring religion if you don't include religion in this, that, or the other thing, and therefore, it's a free exercise violation. And now the Establishment Clause is the nephew locked in the room that you never let out. And so, free exercise now, it's not balanced by anything, even where there could be potential Establishment Clause concerns. And this is extremely dangerous for religious minorities and non-believers.
There's no question. And they built themselves a lemon, the criticism of the lemon test was that it was rudderless and it was impossible to predict, although it tended to be skewed in a particular direction. But if you look at the way the language that they use for the free exercise clause, again, we go back to where I started, a quiet personal prayer, right? So that, yes, there'll be triggers, but it's clear that the trigger will be triggered in a more powerful way the closer you get to mainstream religious practice, and it will take more oomph for that trigger to come when you're dealing with other religion and other religious traditions and contexts. And now all of a sudden we're back to judicial arbitration of these, and in a sense we're back to the Ling case, right? Native peoples' religions, a highway, and now because we don't understand this and because it's different and we have no way to value this, although we all talk about neutrality and the trigger for religion, but if you're talking about someone doing a prayer that is very well understood, both in terms of its form, its context, right? Then the judges there'll be no problem. And there's no structure here. There's no standard. And again, this is where the conservatives ought to be very, very worried. How do you ensure, if you really buy neutrality, how do you ensure neutrality in the way in which you approach free exercise exceptionalism?
Well, and this is where I think there's a couple of things. One that progressives might be able to use, and moderates might be able to use as well. First, to the extent that there was really private prayer going on, that's been protected since Abington and Ingle. You don't even need the free exercise clause for that, because there's a line from Abington, as long as there are tests, there will be prayer in the public schools. Nobody ever said you can't say grace before meals. Nobody even said that, there's lower court cases saying, there's no problem with teachers praying quietly before a meal, as long as it's not, being heavily endorsed in front of the students. So that was already protected. So what's being added here is exactly what you're saying, this sort of protection under both free speech and free exercise for more really what ends up being almost promotion. So if you don't stop the promotion, by dominant religious groups of their religion using government to promote, then you essentially are violating the free exercise clause, because by trying to stop them from promoting, you're distinguishing between religion and non-religion. However, one argument is to flip it. All right, you're taking most of the establishment clause away, where we can use, if the indirect coercion test's left, we'll use that. But you violate the free exercise clause when you promote these religions in a way that that harm other religions. And so it's going to be a real tough tightrope to walk, because they're saying this is all private, it's not the government doing it, right? And so there's no state action according to the court. But there may be a way, because they talk about now the free exercise clause favoring or disfavoring religion is the well, that was, the way we viewed it under the establishment clause, right? And so now maybe you argue that by doing something under free exercise that truly ends up favoring the dominant religion, it's actually disfavoring, you mentioned this when we talked about Carson, it's actually disfavoring non-believers and minority religions, and therefore the government has to give them or us that as well.
Right.
And that includes in the context of free speech. So if that coach can go out to the middle of the 50-yard line and do these things as a matter of free speech and free exercise, then, people from other religions should be aware that it's okay for them to do that. So the fact the Satanists had said they want to come out. Well, if they can find someone who, is allowed on the field that can do that, they should be able to.
That's right. And then we wind up getting World War Z, that wonderful scene before the walls that the Israelis built to keep the zombies out, where you've got all the different sects singing as loud as they can, each within the other, and then chaos ensues. But what you say suggested something that I don't mean to overlook, and maybe we can end with this. To what extent, as I read through this, and you really emphasized it in your comments right now, to what extent have we effectively now morphed the what had been the exception that triggered scrutiny under the Church of the Lukumi Babaluaye, and now essentially that becomes not a predicate to analysis, but the presumption that there is no neutrality, there is no general applicability. And so we've taken Lukumi Babaluaye and we've taken Smith, and for constitutional purposes, we flipped it. So rather than start with the notion that we have general applicability and neutrality, the plaintiff now has to prove that it isn't. We start effectively, if I read this case this way, we start with the presumption that there is no neutrality or general applicability by virtue of the fact that you've asserted that it was your religion that created the disparate treatment, and that therefore now it falls to the defendant to show neutrality or general applicability, which will be much, much harder.
Well, yes, as I think you're right. As soon as that assertion occurs that my religious speech or religious freedom has been interfered with, now it does. I don't know if it firmly shifts the burden of proof, but it certainly now shifts the overall burden of production or whatever to the government. There's no, and again, the establishment clause basis. The establishment clause is now the disfavored stepchild in the closet, right? I mean. The establishment clause is now Cinderella, but with no happy ending. And so this is a problem, right? If you want to view the way the court is using or weaponizing free exercise and free speech in a way that favors dominant religions and disfavors minority religions and non-believers, they've taken away the one defense that religious minorities and non-believers really had, at least, if not completely, at least heavily, and that's of course Establishment Clause.
That's right. And then ultimately as well, they've taken away the idea that there can be spaces, public spaces, from which religion can be excluded. That was actually one of the most remarkable things about these cases, both Carson in its way and now Kennedy, is that the notion of a secular space, a secular political space, a secular social space, is now been overturned. And that in fact, in this country, unlike, for example, in France, which is going in the opposite direction, with the notion of the secular at the heart of the political, that in fact you constitutionally, that a space, any space in this country that is not well marbled with the religious, is almost ipso facto a constitutionally suspect space, especially when the state is involved.
Yeah, I mean, will they move that next step and say, well, you know, it's suspicious, there is no religion in this public space. What's going on here, right? And you know, you don't even have to go as far as France. You know, where really, yeah, secularism is to some extent promoted. Although there's debate about that too, because of the way in which Christianity is a bit privileged. But you can look at Switzerland for kind of like a model where there is a lot of religion in the public sphere, but there's also a promotion of secularism by government is fine. You know,
as a kind of neutral space. But we believe, right, so in our sense, neutral space is one in which all religions are represented, as opposed to a neutral space in which religion, you drop your religion at the door, right? And those are two vastly different models. We have been tending towards the other model. We all understand that you're religious, but you leave that at the door and then you come in and debate. Now we're going to the model, well, if we don't see representation, then we've got a problem. But now we go back to what you've been underlining quite effectively throughout our conversation. If you're going to have a comprehensive representation model, then you better be sure that the people who are there include more than your standard issue, Protestant Christian, Catholic Christian, Muslim, which one, Shia or Sunni, Jewish people, which ones, et cetera, et cetera, et cetera. You're going to have to come up with a system of comprehensive representation. And it's not enough, I don't think, if you're going that route to say, well, you know, that's all there is here. Now, if you're going to be formally rigid, you're going to have to take formalism as it is, and that's going to require a now positive obligation to ensure comprehensive representation, if in fact now this space must be populated with the religion. And that's one of the underlying things. I don't think these justices even understand where they're going with this.
No, they don't understand it. And in fact, that's the problem. The problem is that before, under the jurisprudence we had before, it was already inclusive of religion in public forums, in limited public forums. It was already inclusive, but it was understood that included, you know, because in a public forum, a limited public forum, you can engage in content discrimination. You could have other religious or anti-religious voices speak, you know, or not just non-religious voices. But now the entire thing is rigged in a way that it's primarily rigged in a way that will benefit the religions that both want to speak the loudest and have the numbers to speak the loudest.
Right.
And that's both in the literal sense of speech, but also in the sense of vouchers or things like that. And so, you know, the deck has now been stacked against religious freedom for people who are not in the dominant groups.
Right. And as I recall, your fear then of the problem with the formalism of Galloway is now realized.
Yeah, Galloway was the perfect example of where Judge Calabrese in his Second Circuit opinion had this just, you could see the pain that he went through to explain how this was excluding other groups. It's okay to have, if you really are inclusive, it's okay. But then the Supreme Court ignored it. It's the case that comes closest to Kennedy for gaslighting on the facts, but it's not not as bad as Kennedy on that.
Right, but even
the
there, and you know,
majority
and
ignored the exclusion of religious minorities and
I'm still a fan, right? But I'm still a fan of Galway because I was thinking, if for me, what it did was lay the possibility open to, or it suggested, it ought to have suggested that, in fact, yeah, okay, do this, but now you are going to have to be inclusive, even if you weren't before. Here, we don't even have that.
We don't even have that. And I'm not sure we even had it after Galloway, because as soon as Discovery ended, they went back to their old practice. But of course, the majority ignored that. So, you know, there is the interesting thing in Galloway is that Kennedy may be the, you know, Galloway on steroids, right? So Galloway ignored the facts to the extent that they had any impact on religious minorities or non-believers, or misportrayed the facts, but in more of a normal spinning the facts kind of way, but pushing that envelope a bit.
Yeah, but
and
still,
then Kennedy goes into pure gaslighting the facts. Yeah.
Oh, it goes. Well, we have been speaking for much longer than we normally do, but this is a critically important case. And I know that we've tried our listeners' patience, but
sorry, listeners.
But it probably is time to go. So Frank, any last words or thoughts?
I just say we're, you know, as I told a reporter that asked me about this, we're in the Wild West now. We're in the Wild West. It's, you know, at least for now, it seems like almost anything goes as long as you're a dominant religion, unfortunately. You know, everybody else, no pun intended, be damned. Yeah. That's where this majority has taken us.
And my last words, to quote someone who remains unnamed, revolution is not a tea party, and this is a revolution in which tea is not being served.
No,
we'll
certainly.
See where it goes. We'll see,
and you wonder if Waxa would even be served in this tea party, because I think this is we're trending onto a path that religious minorities and non-believers, and that includes Christian religious minorities. There's no religious majority, but we know who the loudest voices are. They're predominantly socially conservative. They're predominantly white, and they're predominantly Christian. And that's not to state
although that
predominantly a certain kind of Christian. And that's not to say that they don't, I support their free speech and free exercise rights as strongly as I do anybody else's. I just don't think that they should be more strongly protected than anybody else's.
Right, but just a note, I think that on the horizon is the likelihood that the demographic assumptions about who is conservative and who is not in terms of religion and what religious conservatives want is also undergoing transformations, one that is not necessarily reflected in the presumptions in this opinion, and one that is likely going to leave us in a very different shape than when these cases were decided over the last 50, 60, or 70 years. So we'll see. But anyway.
I think you're right. I think where young evangelicals are going, where they're really reading the book very, very carefully and understand, for example, in Matthew, that you should go in the closet and pray in quiet, and the God that hears you in quiet will reward you in quiet. Young evangelicals take that very seriously, and many young evangelicals are much concerned about feeding the poor and doing those things than getting government money and praying at the 50-yard line. And so I do think you're right. I do think that the demographic shifts, even within the evangelical movement, or certainly the political shifts, may be the best hope for religious freedom for everybody else.
Well, yeah, it'll certainly keep us busy. We'll be doing these conversations for a while. Yes. But anyway, thank you, everyone. Thank you again. And we will be back. We've got one more. We're going to be looking at the religion clause permutations and consequences of the Dobbs case, the abortion case, which will be our next one. In the meantime, thank you for listening. And thank you, Frank, as always. Your insights are just astonishing, and I really appreciate them. And until our next conversation.
Thank you, Larry.